Thank you, Sibo, and thank you, Georgiana, for the invitation to today. I do Yiddish. It's perfect. I've been doing this speech in Africa for a year, and I also noticed the lack of this sort of thing you to send to his wishes probably want to talk about. So thank you very much. Part of my research focuses on intramesses and digital markets. Basically, my PhD is about, on the one side, intramesses, on the other side, remedies. So, and we'll talk about the issue in a moment. But I would like to focus on intramesses in this presentation. So, first of all, I'd like to touch upon the issue. Then I'll discuss briefly, go into the substance and the conditions for proposing intramesses. And I'd like to discuss with you some suggestions I make in my research. I do want to give a caveat. It's all very condensed. It's very difficult to condense a research of a couple of years in 10 to 15 minutes. So first, the issue itself. As many of us know, and a lot of research has been done, especially a lot of digital markets are characterized by certain attributes, network effects, scale economies, data advantages, etc., that gives rise to certain feedback loops. And that can make certain markets in the digital economy fast moving. So markets develop quickly. Another effect is that if there is an anti-competitive behavior in the market, will have effects, and these effects can also accelerate due to the fast movingness, let's say, of the markets. But they can also become sustained, and market power can become again established. So the question is, how can we deal with that? And part of the answer as being, if you see Europe, the Digital Markets Act. I'll come back to that in a moment. But at the beginning of my research, I was questioning whether intramesses could play a role. As an example of the fast-moving nature of digital markets, we can look to the Microsoft Teams case. The Commission is currently investigating Microsoft, and its suspicion is that Microsoft has tied Teams to its Office suite as from 2019. And you see here in 2019, the use of Microsoft Teams has exploded. And of course, the numbers are a bit, muddled because of the COVID pandemic, of course, but the complainants, in this case, Slack, you see the same, you don't see a boom in their users. So it's suspicious, let's say. But what I want to show here is the developments that can take place in digital markets in a very short amount of time. Then, let's discuss the tool of intramesses. At EU level, the Commission is empowered to impose intramesses. And boosts are based on Article 8 of Regulation 1 to Paragraph 3. And for imposing intramesses there are three main conditions. The first one is the Commission must establish that there is a situation of urgency, which means there is a situation that there is a risk of serious and irreparable harm to competition. Second, the Commission must prove a prima facie infringement, so an infringement at further sight. A third condition is that imposing intramesses must be proportionate. It's not explicitly noted in the provision itself, but it follows from the EU system. However, intramesses have been used very sparingly by the European Commission. The last time was in 2019 in the Broadcom case, and the time before that was almost 20 years before the Broadcom case was in IMAS Health. Most of us know the IMAS Health case based on the pre-MA reference the judgment of the court. However, there was also a case going on at the Commission, where the Commission imposed interim measures on IMS Health for a refusal to deal. Those interim measures were suspended eventually by Court of Justice, and basically the case ended there. But after that case, no interim measures anymore. Why is a very interesting question, which I will not discuss here. For that, you have to read the PhD. But I just want you to know that interim measures are a very rare animal indeed. So why interim measures in digital markets? Well, because it can be very, very useful. As I noted, the markets are fast moving, so early intervention could prevent damage from accrual. Another interesting aspect of interim measures is that they focus on effects. They focus on stopping the harm, not on, per se on stopping the conduct itself. They aim to prevent serious and therefore very harmed conditions. And that means, and also an aspect of risk to markets, is that if there is anti-competitive behavior in digital markets, the anti-competitive behavior may stop, but the effects may continue. For example, the feedback loops, the network effects, the feedback loops, etc. So it's interesting that interim measures can tackle not only the conduct but also prevent these feedback loops from harming. As I said, part of the answer to the partial solution to the problem of have to have some early intervention was the DMA. However, the DMA only covers part of the digital sector, only a few players. So the DMA itself refers explicitly to the complemental role of antitrust, especially intermediates. However, and that's where my research comes in, to what extent does the current legal framework, which is now under review, the current legal framework, to what extent does it allow for interim mediation for one? And there are three components to that question. One is a substantive, which I will go into in a moment. Second one is procedural, is the procedure fast enough? And the third one is judicial control. How is judicial control structured? Because that can also, incentivize the European Commission for those agencies. But I will focus in the following on the substantive aspects. So first of all, prima facie infringement. That was one of the conditions for imposing interim measures. The question is, however, prima facie infringement. What does that entail? When has the Commission found a prima facie infringement? What should be the legal standard? And because of the fact that interim measures at the EU level are rather rare, we don't have a lot of precedents. So what should be the standard? Because a too high a standard, what might be acceptable in normal markets, might be difficult in digital markets because of the fact that many digital markets are quite novel. We have to understand how they work, understand business models, etc. And that's difficult because they're also quite complex. So should we adjust the legal standards to those circumstances? And what I suggest in my research is that we shouldn't put too high a standard of finding a prima facie infringement. I suggest not to put a standard like the Commission should make it probable, or that there should be a serious infringement. What I would argue for is that the Commission establishes reasonable doubts regarding the legality of the conduct in light of antitrust law. That means that there can be questions, is there really an infringement? That's acceptable because it's only a prima facie finding. So there can be doubts. But I think I would argue that the most important part is to find a coherent theory of harm, to establish a coherent theory of harm, so that the Commission has a theory why certain conduct harms competition. Then, the second condition, urgency. Urgency entails a risk of serious and irreparable damage to competition. I would argue that we focus on the question, what is irreparable or a risk of irreparable damage? Because I find it very hard to understand what a non-serious infringement or non-serious harm to competition is, especially when it is irreparable. So I don't see the relevance that much of the sort of the trying to find what is serious. So I would argue you should focus on the question, what is irreparable and what should be the likelihood. Again, if you put a too high standard in digital markets, that might be prohibitive for using the information tool, because making predictions is already complex, but it might even be more complex in digital markets, because again, they move fast, they're rather complex, and they can be novel. So we should, I would argue, take that into account. So my suggestion would be that the Commission must prove that it is foreseeable that conduct can cause damage to competition, and there are substantial difficulties making hard and therefore uncertain that after a final decision, damage to competition can be repaired. And this aligns with some practice on member state level. For example, the Greek competition authority also has a built-in idea of, well, it shouldn't be irreparable, it should be difficult to repair, and it should take account of the uncertainties in that respect. So again, not too highly standard. But that would lead to the question, okay, when you impose interim measures, the Commission could also be wrong. So type 1 errors, which are inherent in interim measures, but are compounded if we would lower the bar, so to say, to establish lower standards. And this might especially be difficult in digital markets because error lists might be more frequent or more likely because of the complexities and the novelties. A second risk is that type errors might be more serious in digital markets because they move faster, because also intervening by the Commission might cause effects that are amplified. So there are also type 1 errors that are compounded. And in my research, I suggest that we should include those risks in a balancing of interests. And I would argue that instead, and that's what the Commission is currently doing in its practice on interim measures, is really focusing on the first conditions. We have to find an infringement. We have to find that it's irreparable damage. But I would argue those are more eligibility criteria. That's a minimal standard. And then the Commission in a second tier, so to say, should balance the risks involved. That can mean, for example, that the Commission is able to impose interim measures where its finding of an infringement is not, there are serious doubts, but it's not that convincing if the potential harm to competition is very great and very light. Here you see balancing of the different aspects. So that's basically what I want to present here. It's a proposal to not to change the provision, not to change Article 8 of Regulation 1/3, but to change your understanding of it, to change the perspective, and to focus on balancing the interests. It's not uncommon because the Autorité de la Concurrence already seems to do so, focuses on proportionality, but more particularly the Belgian Competition Authority really focuses on balancing the interest involved. So I would argue that to transpose a similar framework to or approach to the EU level. And with that, let's Annie, thank you for listening to Chiga.
I think straight to Bella for your challenge, Neha.
Yeah, thank you. Although I'm the devil's advocate, I like to start with a counter. I really enjoyed your presentation and especially the point you made on harm. So that's my first point. I also had the second point related to methodology. With regards to the harm, in your introduction you said that the focus on harm rather than the conduct as such is one of the benefits of the interim measures, which is a really interesting take. And therefore, I was really surprised that this criterion of harm wasn't coming back in the proposed setters. Could you explain why it's not part of the framework due forward?
I think the harm or the risk of harm, I want to put in the balancing. So if there is a risk of harm, it should be balanced against the risk of harm for the undertaker. So there, I think the harm comes back, but it should be balanced. And I think that's also interesting to add that in the proportionality assessment, I would argue that we should include the type of measure it imposes. For example, if it's imposing interim measures that change the status quo or that do not necessarily relate to the conduct, to the harm as such, that should also be an element in the proportionality assessment. So I think that's how it comes back in the framework I propose, or at least I try.
Okay, thanks. Can I make one brief one? In terms of methodology, in the research question, you assess whether the framework allows for interim measures. Allow is a pretty gold standard, so I wonder whether you define it further or which parameters you use. Are you looking at the law in the books, also the law, or the law on paper, or also the reality or the decision-making practice?
Yeah, good question. I started off quite broadly because there was no law of precedence. So the question was, there are no law of interim measures. Does the system allow for it in a way that would it, can it? And so that's my basic point. And then in further on my research, I developed more like suggestions how to improve it, taking also into account how can we improve it, taking into account the interests involved. So the interest of protecting competition, but also the interest of the undertaking. I think that's comes later in my research, where I try to balance different interests, trying to improve the system. But to come back on that, I would say allow is a broad question, and the question or the answer to the question is actually yes, the system allows for interim measures. But what are the difficulties then? And those difficulties are more practical.
We move to Kenna for a contribution.
Yes, thank you very much for your great presentation. Actually, I would like to say that, for example, in your introduction of your research, you mentioned that because currently there are limited cases in practice where the Commission has used these interim measures. So I would think that maybe it would be interesting to provide some analysis, especially from the empirical perspective. For example, to give some interview or some empirical analysis about why the Commission feels that it's difficult. From your presentation, I see that maybe it's because like the high standards. But on the other side, I would think that maybe there are also some empirical difficulties. For example, it's difficult to make a balance between the interests, especially to make the balance between the market structure analysis about how these digital markets will be developed. For example, if we think about the standards too high, though in lower standard, though could we use the lower standards to address the challenges the digital markets also in the future, like the AI markets. So I would like to see that maybe it's also be interesting to see that how you use your lower standards to address some challenges or some practical issues. For example, if that's possible for you to use your standards to provide some analysis in some decisions or the case judgment that has already been decided by the commission or by the EU court. On the other side, is it possible for you to use your lower standards, and then we can really foresee or really address some challenges maybe in the future in AI markets. So maybe in your KIPC research, you have already involved these issues in your chapters, but I think that's from these two perspectives, it will be interesting. On the one hand, empirical studies, on the other hand, how to make some analysis in the cases that's already been discussed or in the future. So.
Yeah, thank you very much. Two very interesting points indeed. First of all, the practical reality. So, is it really the standards? It might also be different, more about hidden issues. I've been talking to you a bit from this mission, and there seems to be also some other hidden reasons for not imposing intro fees. As for more like the putting into practice the standards, I've indeed been thinking about defining them and showing whether there's a difference and how. Yeah. So thank you very much.
That's a trick I was given by my PhD supervisor, Spencer Water. When I developed the framework for my PhD, he told me, well, that applies to past cases and see what it means. Yeah. Does it change something? Maybe it does not. What's the reason behind? And I could see that people enjoy reading as far as. Yeah. Thank you very much. Georgiana, I see that you assigned yourself the very good role of praising daily fears. Please go ahead.
Yes, I had a feeling that it was going to be easy to do that, and I was right. So I'm very happy with my choice. No, I really enjoyed it, and as already has been highlighted, there's much to commend about the presentation. I particularly liked the fact that you highlighted this almost as a revival of the tool for digital markets, and that you contextualize how this tool can be used in this specific context and not just in the abstract. And I think that's not only topical, but also helping you in framing your research and the answer and the test that you come up with. And I also like that you acknowledge the tension between the need to impose interim measures and the fact that digital markets make predictions difficult, and that therefore you can be quite wrong about the prediction that you make. And I also thought that you are aiming to provide an actual tool that enforcers can use, a legal test, with your research. And I think that's always helpful, rather than just look at possibilities. So I quite enjoyed it, and I learned a lot from it.
I think those will go for it. Do we have questions? We have 5 minutes for more questions. And we also joined by, I wanted to mention you, so FM question, Professor Wolf Salter from VU and the ACL. So please go ahead.
I thought it was an interesting presentation. I don't know much about the interim measures, but I do have a question. Are you drawing any inspirations from other areas of law? I think similar procedures exist in civil law and administrative law, between a summary of proceedings where similar standards are applied. Is proportionality really used there as a good source of inspiration? And the second question, which you don't have to ask, but I don't want to take too much time, is you mentioned that this procedure is under review. Is that the review of Regulation 1/2003? And is there anything you can say about
As to the first question remark, do I draw inspiration from different system or areas of law? No, I want to do that, but I'm a bit too big. But I find it very interesting. I do draw inspiration from national video systems. That's why I mentioned the AutoBT and the BMA, Belgian Competition Authority, because at national level we see more activity with the internet, especially the Belgian Competition Authority and the French Competition Authority, but also the Italian Competition Authority and the Greek Competition Authority is also been thinking about intermeasures more sensibly. So I do draw a lot of inspiration from that. Also because they're more related to intermeasures and system intermeasures for the European Commission. Also the procedure, because that also impacts the substantive part. Even judicial part impacts the substantive part. So I want to keep it sort of close to the system at commission level. So I decided to compare and draw inspiration from national systems.
Thank you so very much, David, again, to run of the studies.